counsel, you received all discovery. Did you review that with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Tamayo, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, I did, and I would like to address the court so I can just let you know what I'm doing in Texas. I'm from California.
Okay, I mean,
It ain't gonna make a difference.
all right, then maybe your attorney doesn't want to talk about what you're doing here. All right, counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Proceeding on count 2 waiting.
Any objection?
No objection, Your Honor.
All right, did you review the document entitled Court Admonishments and Defendant's Waivers with your attorney? Did you understand it?
Yes, ma'am.
Did you sign it in all the appropriate places?
Yes, ma'am.
Do you understand your charge of possession of a controlled substance, penalty group 1B, 4 grams to 200 grams? That's a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes.
Today, we've got a front row seat to a courtroom meltdown featuring a violent offender who's about to discover exactly why disrespecting a judge is one of the worst moves you can make. From the moment he walks in, his attitude is impossible to ignore, rolling his eyes, scoffing, rocking back and forth in his chair, and acting like the entire proceeding is beneath him. One of the first rules of any courtroom is simple: if you have an attorney, let them do the talking. They're there for a reason. But this defendant seems determined to put on his own performance, treating the courtroom like an open mic night instead of a place where his future is being decided. As the hearing unfolds, every gesture and reaction makes the situation worse. Watching him challenge the atmosphere of the courtroom is like watching someone pour gasoline on a fire and then act surprised when it spreads. The tension keeps building, and you can tell everyone in the room is noticing his behavior. What do you think? Is this guy simply being disrespectful, or is he making a massive mistake that could come back to haunt him? Let's jump into the hearing and find out how it all unfolds.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in, the right to remain silent?
Yes.
Did you understand by entering this plea you were giving up those rights?
Yes.
And did you intend to give up those rights and enter into a plea in this case?
I try not to, but yes.
Well, I mean, it's either you did or you did not. If you want a jury trial, we can set you for jury trial.
No, I just give up the rights.
All right.
Right?
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Tamayo, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, but I would like to
Anyone?
say something.
Yes.
I came to visit a cousin in July, and I was here only for a month. It took 5 months for me to see a court date. I lost my brother. I lost my cousin that I came to visit while I was in incarcerated. Lost my aunt. Lost my sister-in-law too. And I was hoping for probation. You know what I mean? Go to Victory Outcry and get a blueprint and help out the community. Give you guys a year and have the community speak for itself. You know what I mean?
All right. Well, what I can tell you is this is Texas, not California, and that's not the way things are done here. So my question is,
I also know what's constitutional.
has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
Nah,
Anyone promised you anything other than the plea?
I just finished doing 10 years.
All right. Has anyone promised you anything other than this plea bargain agreement?
No,
Are you satisfied with the way you've been represented?
anywhere I can't complain.
All right. Are you a U.S. citizen?
Yes, I am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
I understand it all.
According to the plea, state is proceeding on count 2. Punishment is to be assessed at 3 years in the prison. There's a $2,000 fine and there are no applications. Did you understand that to be the plea?
Yes, ma'am.
Defense, is that the plea?
Yes, Your Honor.
State, is that the plea? Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, are there being such motions?
No, Your Honor.
Into the offenses charged in count two, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
State offers State's Exhibit number 1 and attachments.
No objection, Your Honor.
All right, you may be excused. Did you review the waiver and consent to stipulation of testimony and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same.
I signed a paper to get extradited. They said 30, 60, 90 days. Am I gonna get extradited back to California?
Things take an even stranger turn when the defendant casually tells the judge he'd rather be sent back to California. At that moment, you almost have to wonder if he forgot where he was. This is a sentencing hearing, not a travel agency. The comment leaves everyone scratching their heads. Instead of focusing on improving his situation, he seems more interested in making demands. Meanwhile, Judge Boyd's patience appears to be wearing thinner by the second. You can practically feel the frustration building in the courtroom. His attorney doesn't have an easy job either. You can see him trying to maintain composure while his client continues making things harder for himself. Every unnecessary remark seems to dig the hole a little deeper. What's most surprising is the confidence with which the defendant carries himself. He acts as if he's in complete control of the situation, despite all signs pointing in the opposite direction. Whether it's overconfidence or a complete misunderstanding of reality, it's difficult to say. Either way, it's becoming increasingly clear that this strategy isn't doing him any favors. Let's see how much longer Judge Boyd's patience lasts.
You're going to serve your time in custody in Texas prison, and then they will transfer you.
I thought I was gonna get extradited before that.
All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Oh, hell yeah.
All
I
right.
love Texas. Yeah.
Court will sentence you to 3 years in the prison. There's a $2,000 fine, time and money to run concurrent. There's to be no contact with Sandra L. Torres.
Why is that?
All right. Counsel, is there anything else with regards to sentencing?
No, Your Honor.
All right, did you review the trial court certification of defendant's rights? And I'm sorry, also no contact with Julian Rodriguez
How do you know that, dude? I met him that day.
and Christy Brown. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? Because this is a plea bargain, counsel, did he review the document?
Yes, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Good luck with you.
So, what do you think? Was a 3-year sentence justified? What's remarkable is that this defendant had only recently been released from prison before finding himself right back in another courtroom facing more time behind bars. Instead of learning from past mistakes, he appears to be repeating the same pattern all over again. Throughout the hearing, his attitude remains one of the biggest talking points. Even while facing serious consequences, he seems unusually relaxed, smiling and laughing as though the situation isn't affecting him at all. For most people, the prospect of returning to prison would be a wake-up call. For him, it barely seems to register. The judge ultimately hands down a 3-year sentence, bringing the hearing to a close. Whether viewers believe the punishment was fair or too harsh, one thing is certain: the defendant's behavior throughout the proceeding did little to help his case. At some point, everyone has to decide whether they're going to learn from their mistakes or continue repeating them. Unfortunately, this defendant appears to have chosen the second option. Let me know your thoughts in the comments. Was the sentence appropriate, or should it have been different? Thanks for watching, and don't forget to like, subscribe, and turn on notifications for more courtroom content.